Hello everyone, and welcome to the Legal Access, where we talk everything commercial and labor law. My name is Mesha, and today we are going to be discussing dismissal. I don't know why I'm so nervous today. I don't know how many times I stopped the recording and re-recorded, but anyway, I'll put myself towards myself. I'll be fine. Thank you to everyone that subscribed. Thank you to everybody that paid for the workshop, and thank you for the likes, for watching, for telling people about it. I appreciate it. Okay, don't mind my nerves. I don't know what's happening with me today, but I'm gonna try my best. All right, so we'll be discussing misconduct and incapacity. Okay, so misconduct is the one we used to it's basically dismissal for behavior, the employee's behavior. It does not look at the capabilities of the employee, but the behavior of the employee. It is the one wherein you would start by giving an employee a written warning, maybe for late coming or for insubordination and all of that. The one, like I said, the one that we used to. And under misconduct, you don't necessarily have to always give a written warning. There are instances where an employee can be dismissed without a written warning. And those are instances wherein the misconduct is so serious that it threatens the employment relationship. Like, it will make it intolerable to continue with the employment relationship. An example of that would be if the employee just willingly destroys your property, or attacks another employee, or attacks a client or a customer. Yeah, in that instance, you can dismiss an employee without a written warning. However, the dismissal still has to be fair, and that would mean giving the employee a chance to tell their side of the story. Whether, we like disciplinary hearings. We're used to disciplinary hearings because, well, in the workplace we want to formalize things, but the law does not necessarily say have a formal hearing. The law just says give the employee a chance to first prepare their answer to you. Why am I so nervous, guys? I don't know. Give the employee a chance to prepare for their defense, to defend themselves against the accusation. It does not have to be so formal, but from me, in my personal opinion, it is advisable to have a disciplinary hearing. That way you have record of what happened. Like, when you formalize things, it's easy to record the proceedings. Okay, but the law just says give the employee a chance to prepare and then tell you their side of the story. Basically, it does not have to be formal, but it's advisable to have a formal disciplinary hearing. Yeah, and then after that, so you can dismiss the employee. Okay, that is misconduct. It looks at the behavior and not the capabilities of the employee. Okay, then there is incapacity. Incapacity would be poor work performance, right? That is when an employee is incapable of performing the duties that are expected of him or her. And it is usually because of circumstances that the employee cannot control. For instance, if the employee is not qualified, the employee does not have knowledge, or the employee is sick, that is incapacity. It is not negligence, because it's usually confused with negligence or misconduct. It is not a misconduct because it has nothing to do with the behavior of the employee, and it is not negligence. The employee did not neglect anything. They just cannot, and that is something that is out of their power. Okay, I hope that makes sense. Okay, so with incapacity, because it is not due to behavior, there cannot be a disciplinary hearing. There has to be meetings, okay? You have to meet with the employee, well, the manager, representative from the company. It can be you as a CEO or whoever, like in management, and then with the employee. The employee does not have to have legal representation. Like I said, I don't know what's going on with me, so I don't have an explanation for my behavior right now. Okay. The employee does not have to have legal representation or representation from a union, whereas in a disciplinary hearing, the employee can have legal representation or representation by the union. But with these meetings for incapacity, you don't have to have any of that, because the employee is not being disciplined. It's a meeting to discuss what is the reason for the incapacity. The employee is given a chance to explain to you why are they incapable of performing their duties. It can be maybe they're going through a divorce, they're stressed, they're depressed, or they just don't know how to do the job, or they're sick, anything like that. So with the meetings, you have the first meeting, the employee explains to you what their problem is. You make it clear what their duties are, the duties that they're supposed to perform, that what is expected of the employee, and then the employee tells you, okay, this is my problem. If it's training they need, you train the employee and then give the employee time to improve. You don't just have that meeting and then next thing the employee is fired. No, you have that meeting, give the employee time to improve. If they need training, you give them training, and then you have another meeting. If there's no improvement, you have another meeting. You can have up to at least 3 meetings with the employee, obviously changing what you talk about and all of that, so that you can find out what the problem is, try different tactics, and after each meeting you give the employee significant time to improve, like a few months to improve, and then come back, have another meeting, give them time to improve. You can dismiss the employee maybe after 3 meetings and there is no improvement. Please excuse me, please note that these meetings have to be recorded. Whether you write down or you record, using a recorder, doesn't matter, but you must have a record of these meetings so that the dismissal is deemed to be fair should there be conflict in the future, So yes, those are the differences between incapacity and misconduct. It's easier to dismiss a person for misconduct than it is for incapacity, because incapacity, it's not the employee's fault, and misconduct is the employee's fault. The employee has to be disciplined, and if they refuse to be disciplined, they have to leave your place of business. So yes, always follow fair procedure when you're dismissing an employee to avoid going to the CCMA and being sued and all of that. So follow fair procedure, and if there's anything you don't understand, call that legal consultant and they will assist you with everything, because you cannot know everything as an employer. You need assistance here and there. You can call a labor consultant or an attorney who specializes in labor law. I just advise that when you have a specific matter, call a specialist who specializes in that area of law. If you have a labor law matter, call a labor law specialist. If you have a criminal matter, now I'm no longer talking to business people, but yes, if you have a criminal matter, call a criminal law specialist. I think it's easier that way, because then the person knows exactly what they're talking about, you know. Okay, that's it for the dismissal video and the workshop. Still on the 28th of August, still accepting payments. Yeah, and I'll see you there. I'm sorry for this video, I was not myself, like I said. I don't know what's going on. Maybe it's just one of those days, you never know. Anyway, thank you for watching, and I'll see you next week.